Good afternoon, and welcome to the University of Georgia School of Law. I want to thank you for your attendance today as we hear from Professor Aziz Huq. Here at the University of Georgia, we are committed to redefining what it means to be a great national public institution, offering a hands-on, purpose-driven educational experience with a pioneering commitment to accessibility and affordability. At the law school, our mission is defined by 3 words: prepare, connect, lead. We prepare our students for real-world practice while connecting them to professionals and legal leaders in the community, all while striving to be the best return on investment in legal education in the country. Events such as today's, the 122nd Sibley Lecture, are an example of offering our students the chance to connect with a preeminent legal scholar before they embark on their professional careers. In 1964, the trustees of the Charles Loredan's Foundation of Atlanta established the Sibley Lecture in tribute to the late John A. Sibley, who was a 1911 graduate of this law school. Thanks to the foundation, this lecture series honors the leadership and public spirit of John Sibley, whose service to the law school and to the state of Georgia extended over a period of nearly 80 years, and gives our students the opportunity to connect with legal thought leaders from around the country. In the 60 years since the Sibley Lecture Series was established, the law school has attracted outstanding legal scholars from across the nation to visit and speak on a variety of topics here in Athens. The first lecture, given by Yale Law School's Professor Myers S. McDougall, took place on November 30th, 1964, and focused on jurisprudence in a free society. Since then, the law school has hosted many other influential speakers, including Supreme Court justices and future Supreme Court justices, other distinguished members of the judiciary, legal academics, and legal professionals in public service. Today, we are pleased to welcome Aziz Huq, the Frank and Bernice J. Greenberg Professor of Law at the University of Chicago School of Law. Huq is a scholar of U.S. and comparative constitutional law, and his recent work concerns democratic backsliding and the regulation of AI. His award-winning scholarship has been published in several books and in leading law, social science, and political science journals. He also writes for a variety of well-respected news outlets. He has an active pro bono practice and is on the board of the American Constitution Society, the New Press, and the ACLU of Illinois. Before joining the University of Chicago faculty, he served as counsel and then director of the Brennan Center's Liberty and National Security Project, litigating cases in both the United States Court of Appeals and the Supreme Court. As senior consultant analyst for the International Crisis Group, he researched and wrote on constitutional design and implementation in Pakistan, Nepal, Afghanistan, and Sri Lanka. Huq was a law clerk for Judge Roger D. Sack of the United States Court of Appeals for the Second Circuit, and then for Justice Ruth Bader Ginsburg of the Supreme Court. He is also a 1996 summa cum laude graduate of the University of North Carolina at Chapel Hill, and a 2001 graduate of Columbia Law School, where he graduated first in his class. Today he will present the necessary and proper stewardship of judicial data, which I'm sure will be a thought-provoking lecture. Welcome, Professor Huq, and thank you.
Thank you so much, Professor Rodriguez, for that very generous and kind introduction. It is, as you intimated, an honor to present the Sibley Lecture, some 60 years after the series was inaugurated, some 50 years after, as you said, Professor McDougall delivered the first one. And I'm very grateful for that opportunity to add a link to this vital chain in the American legal tradition, something that makes up an important part of that tradition, I'm grateful to Dean Rutledge, who I know is traveling today, also to Professor Rodriguez and her colleagues for the generous hospitality you've already shown, and not last but not least to Laura Pulliam, who has made the trip and arranging the visit very, very smooth and easy to do. So thank you to all of you. My topic today is about how an institution central to all of our study and work, the federal courts, should respond to a new technological reality, the emergence of a vibrant economy and data that can be used for analysis or inference for public good or private gain. The ambition of the talk and the underlying paper, which is co-authored with Professor Zach Clopton of the Northwestern Law School, is to identify a suite of questions that are salient to public policy and to set out some preliminary thoughts about the range of sensible answers that can be given to those questions within the bounds of law. And as I read the history of the Sibley lectures and the ambition behind their creation in the first place, that the ambition of stimulating public-minded reform with respect to our core legal institutions through legal scholarship seems to me in the spirit of the best and most interesting examples of the lecture series. So let me begin by offering you a statement of the problem that I want to talk about today. In 2001, there were 526,477 civil or criminal cases filed in federal district court. In the same year, there were 326,077 cases resolved in the district court. At the same time, 46,165 appeals were filed in the 12 regional courts of appeals. All of those numbers are dwarfed, as you can see from the chart, by the number of cases, matters, filed in federal bankruptcy courts. Every single one of those matters could, in theory, leave behind an informational footprint, even if today many do not. Every one of those matters creates a cascade of records. This starts with the complaint, the document familiar from civil procedure that begins a federal court litigation. A complaint is accompanied in almost all federal district courts with a document called a civil cover sheet. On a single page, the civil cover sheet contains information that maps out the universe of all federal court litigation. Details such as the basis of statutory jurisdiction, the type of relief sought, and a code called the Nature of Suit Code that designates the nature of the litigation initiated. And as that litigation unfolds, as motions are filed, evidence is introduced, and outcomes piecemeal resolved, so too the data entailed by those resolutions, by those judicial actions, can either be captured or lost, preserved or frittered away by the federal courts. The ordinary process of federal litigation, in short, generates an enormous volume of data. Across the economy as a whole, we now well know, data is recognized with growing frequency as a key economic resource. One doesn't need to buy the somewhat cliched claim that data is the new oil to see that there is enormous value in being able to capture and exploit streams of data. Just look at the market cap of the GAFA corporations for evidence of that. Judicial data, is just like other raw materials of informational business. It can be captured and exploited, and its surplus value can be assigned either to public uses or to private uses. It can be used for more or less regressive ends. This is especially true today, as we stand in the wake of the revolutionary developments in large language models, tools like ChatGPT, that can extract immensely insightful inferences from very large pools of data. Using large language models with respect to judicial data it is possible to map out a range of issues about how the federal courts work in ways that advance legality and increase the quality of access to justice. That data can reveal shortfalls in judicial practice. It can enable the provision of cheaper, better targeted legal services, thereby facilitating access to justice. Here is an example of one such possibility from a study that my co-author was involved in. Every federal district court has the discretion to grant IFP, informa pauperis status, thereby waiving a number of filing fees that litigants would ordinarily be subject to. Federal law doesn't clearly state what the standard is for granting IFP status. And the study in question revealed that once one looks at the characteristics of litigants seeking and obtaining IFP status, there is enormous variation both between federal district courts and even within the same federal district courthouse, as between different judges. For example, in one single district court, judges granted IFP status at rates ranging from 20% to 80%, essentially confronted with the same stream of litigants. So this study suggests that there is an important need for standardization, a shift from standards to rules, right, to use the language familiar from conventional legal studies, in the context of IFP status. We have the possibility of identifying with more accuracy and channeling better resources with respect to those who need them in order to access the important good of federal court litigation. Yet this study cost $100,000 just to acquire the data, to say nothing of the cost of analyzing, cleaning, and then analyzing that data. For practical purposes, the costs of this study make it almost impossible to replicate. You don't get $100,000 from your law school every day of the week. How then is judicial data produced and husbanded? What is its current stewardship? What is the legal regime that governs the data produced by federal courts? There's a large scholarly literature about the analog question when it comes to Congress. There's an even larger body of literature about the informational dynamics of the executive branch. Think about literatures on FOIA, on various kinds of sunshine statutes and disclosure regimes. However, in contrast, the legal regime that judicial data is subject to is an object of almost no legal scholarship, and as it will turn out, and I'll explain momentarily, actually very little legal regulation. This is a domain which you might think is important to law and to legal practitioners, and yet it's not studied, and in fact it's not formally regulated in many ways. And so one of the goals of the project that I'm discussing today is simply to bring to light a set of questions about how a particular public resource is managed and used in a way that enables conversation about that resource, the resource of judicial data. So let me start out by offering you a very simple account. This is actually going to be the body of my remarks today. Of how data is produced and some of the key distinctions and decisions that go into that flow of information. I'll then introduce the question of how judicial data is regulated. What is the law of judicial data, and what might the law be? That's the point on which I will close. This is a highly simplified diagram of the flow of information through the litigation process in the context of the federal courts. And I will step us through it, but drawing attention to a number of different points that I think are key to the manner of production and preservation of judicial data. So the first thing to observe is that at the front end, judicial data is created by a mix of action by people who are internal to the federal courts and people who are external to the federal courts. Think about what I described as the filing of a complaint along with a civil cover sheet. right? The complaint obviously is crafted by the lawyers or by the pro se plaintiff, but the form of the civil cover sheet and the nature of the categories of data that are contained in that document, a document, remember, that every single case that's filed in a federal court has to have, right? Those categories are a function of decision making within the federal courts. Second, once a case has started, the data produced by that case flows through, or is not just concentrated in a single place, but it flows through a sequence of different databases that are associated with different institutional actors and that have very different access rules. So, until around 1980, federal courts were not required to have electronic filing systems. Many of them did not have electronic filing systems. Everything was on paper, and to the extent that it was preserved, you have to go to the courthouse and find it. When we were doing this research, we talked to a number of judges, we talked to a number of staff in various offices, including in the Seventh Circuit, which covers, among other states, Illinois and Wisconsin. And we a number of times heard what might be apocryphal, might be true story, of a magistrate judge somewhere out in the west of Wisconsin who did not allow anyone to file anything electronically. He did everything on paper. We were trying to figure out who this judge was, but we haven't been able to figure it out, but we did hear that story from multiple people. So in 1980, the federal courts moved to their first electronic filing system, which was called AIMS, the Automated Information Management System. That has since been superseded by something called CMECF. Those of you who go on to practice will come to deal with CMECF to your pleasure or pain. Don't know. CMECF, therefore, is the central repository into which litigants and actors in the judicial system place all information respecting what happens in a case. The CMECF system, which is the first step in this chart, however, is highly decentralized. Each CMECF system is run by the district court or the court of appeals in a locality. What does that mean? One thing it means is that the systems, at least now that this is changing, are not interconnected and they are not interoperable. They're different computer architectures that cannot speak to each other. One of the retail consequences of that, if you're a lawyer, is that if you have a CMECF password, let's say for a district in Georgia, you can't go and use that CMECF password in Illinois or in New York. Every single system has its own password. Moreover, if the Federal Judicial Center, which manages, among other things, the integrated database, if the Federal Judicial Center or the Administrative Office wants data from a district court, it has to ask the owner, this is the language that we kept hearing, the owner of the CMECF system in question, which was generally the clerk of the court. So at the front end, all data is captured at the CMECF level, but the CMECF database is not a central thing. It's an incredibly fragmented set of inconsistently architectured databases. So that's the first step in the process. One more point about the CMECF. Because the CMECF is designed locally, there are local variations in the kind of data that is acquired at the front end of litigation. So, for example, the contents of the civil cover sheets can vary as between different courts because the mechanism or the interface of CMECF is a local, not a national decision. All right, so that's the first step in the analysis or in the system. Second step, there is an air gap between the database that actually holds all of the working data employed by the federal courts, CMECF, and the database that any litigant or researcher can access in order to understand what is happening in the federal courts. You and I cannot go into a CMECF database. We can't use the data that's in there. We go to a separate database called PACER. PACER is not the same as CMECF, and it's not entirely clear that everything that's on CMECF ends up in PACER. This is one of the gaps in our, or one of the questions in our research that was not entirely amenable to answers from the people we spoke to. But it is worth stressing that nobody outside the court system has access to the actual repositories of working data that are the bread and butter of federal court labor. PACER, as those of you who have tried to access it will no doubt know, is at best a slow and kludgy interface or access road into data. For example, it is almost impossible, except without spending an enormous amount of money and an enormous amount of time, to conduct large-scale searches, large-scale research on PACER. PACER forces you to engage in retail searches, not just at the level of single cases, but often at the level of single documents. This is not happenstance. This is a design decision. PACER is designed to make certain kinds of research more difficult. Moreover, the back-end databases that are public, the IDB, as I mentioned, is the public database preserved by the federal court's administrative structures, is intrinsically limited. The Federal Judicial Center does not allow you and does not publish any records that would allow you to make searches by judges. It is extremely difficult, therefore, to use either PACER, which doesn't allow for large-scale searches, or the IDB to figure out what a particular judge is doing and compare it to what other judges are doing. So, for example, studies of whether there are inter-judge variances with respect to sentencing by race or by gender are almost impossible to do, given the nature of the data that is preserved and released in the form that it's released in, very kludgy and very cluttered, by the federal courts themselves. That is not an accident, very much on purpose. There's a number of different aspects of the system that I have just described that increase either the cost of accessing data on the part of the public, including researchers, or make that data radically incomplete or dramatically unreliable. One of the projects in the underlying paper is to map out some of these sources of data loss and domains of what we call dark data. But what I want to do is to identify 4 points that are salient across different moments of the judicial data flow as instances in which there is what you might characterize as unforced data-related error with respect to judicial data. So the first of those is the fact that some data is never recorded at the front end or as you go through the process. One example of that is it appears to be the case that if a judge decides to hold a colloquy with lawyers or with a litigant and decides not to call a court reporter or not to record through a minute order the existence or the fact of the colloquy in PACER, there's just no record of that happening. I mentioned the judge allegedly in Wisconsin who doesn't allow anything to be put onto into electronic form. Maybe that's another example, although it's not entirely clear. Second, the courts can choose to capture data in ways that dramatically reduce its usefulness. So one example of that comes from the Northern District of Illinois, which includes Chicago, where I live. In the Northern District, in any criminal case, if there is a charging document in the criminal case, if there is a warrant, or if there's any associated document that includes the signature of a criminal defendant, all of those documents are filed on paper. None of them make it even into CMECF, let alone into PACER. So there's a big slice of data about who is being charged, when they're being charged, what basis they're being charged on, that simply doesn't appear in the records, again, by choice, right? So that's slicing the data in a way that some of it appears, some of it doesn't appear. Third, there are species of data that are produced in the course of litigation which could be recorded. There's no rule against recording them, but require an affirmative action by one of the litigants in order for that information to be captured. So one of the example of that is transcripts. If there is a hearing, in many courts, maybe not all courts, there needs to be an affirmative request by one of the litigants to create a transcript, right? And then that transcript gets placed into CMECF and then into PACER. Expert reports. When we spoke to Lexis, Westlaw, and Bloomberg, one of the forms of documentation that they identified as being most valuable to their clients was expert reports. Expert reports, however, precisely because they're valuable, often do not get introduced into CMECF, let alone into PACER, and it's really hard to find them. One of the consequences of that is where you have litigation where the expert report is pivotal to the resolution of the information. Think of mass tort case, many kinds of mass tort cases. Those reports are simply unlikely to be available because litigants will predictably decide not to introduce them into CMECF. Fourth, there are many kinds of data that are recorded in CMECF, but that are recorded in ways that make them unusable or unreliable, in ways that complicate or make impossible subsequent kinds of analysis. Perhaps the most important of these is the nature of suit code that I mentioned earlier on. Remember that the nature of suit code is a single value which is recorded on the civil cover sheet. If you wanted to know what kinds of cases were filed in every federal court, or in the federal court here, in, let's say, the month of February, what you would need to do is to look at what the nature of suit codes say. The problem is that the nature of suit code is selected from a list that's prepared by the court by the lawyers. The list of nature of suit codes, if you go through it, it has things like rate regulation, categories that clearly were present in federal courts in the 40s, 30s, 40s, 50s, not so present today. The list is not updated all that much, right? There's no like cryptocurrency bankruptcy category or the like. And second, the actual data input is being done by a lawyer who really doesn't care whether they are getting it right? The lawyer who's filing the civil complaint has to fill out this cover sheet. Predictably, this is the last thing they do. They're trying to get the complaint in. They fill out this sheet. They hit this nature of suit code. They're like, I don't know, it's a tort case. Bang. Those nature of suit codes, therefore, studies have shown, are highly variable in quality and deeply error-prone. What that means is that the one parameter that is associated with every single federal case that could tell us what the distribution, what the flow, what the cyclicality of different kinds of litigation in the federal courts looks like is a really, really noisy signal, right? So that's an example of something that is an important piece, or important for public policy purposes, piece of data, but that is very, very hard to access, or is unreliable in the form that it's been recorded. Does it have to be this way? Let me turn now to law, and I realize I have about 10 minutes. Is that all right? Okay. I will take 10 minutes. Does it have to be this way? The law of judicial data is incredibly sparse. There are a couple of provisions in Title 28 of the US Code enacted in 1948 that required courts to preserve their data. There's some language in the Federal Records Act that covers courts. There's an e-government act from 2002. But by and large, the pattern of federal data collection and preservation is a function of dispersed, disaggregated decisions by not the judiciary as an institution, but by local courts. Local courts, the clerk here in the districts of Georgia, the clerks in the Northern District of Illinois, they are just they are exercising discretion with respect to the nature of judicial data collection and preservation. It doesn't have to be this way. One of the points that Professor Clopton and I develop at length in the paper is the fact that Congress has very broad authority to regulate judicial data. Not to recapitulate that doctrinal argument in detail, but to summarize it, the text of both Articles 1 and Article 3 of the Constitution, the statutory practice dating back to the 1789 Judiciary Act, and the observed practices of institutions such as judicial actors like clerks of court suggest that Congress has sweeping authority to promulgate binding rules of practice and procedure. Of course, federal courts have inherent authority to set those rules in the absence of congressional action, but with the exception of a narrow category of inherent authority that pertains primarily to the federal court's promulgation of judgments, the extent of congressional power is basically unlimited. How then should Congress use the constitutional space that is available to it for the regulation of judicial data? How might it better discipline the production and the dissemination of judicial data? Well, one possibility is that it uses that data to extract economic rents. Just a couple of weeks ago, the Center for Medicaid and Medicare Data announced that it was terminating all public access to Medicaid databases. And it was transitioning to a database that would only be accessible upon the payment of a relatively high fee. That is, really important public health data is now only going to be available at a cost which excludes a whole slew of important public health research. Right? That's one possibility. I don't think it's a good path to take. In my view, and this is the point that I will conclude on, it would be far better for Congress to recognize the fact that judicial data is a public resource and ought to be treated in ways that draw out its public good qualities. That's not to say there is no role for commercial databases like Lexis and Westlaw, but there are many entailments, many use cases of judicial data that if you rely upon profit-oriented data cartels, as Sarah Landon calls them, you're simply not going to see those use cases emerge. Rather than viewing judicial data as an as a source of economic rents, therefore, it should be seen as a public asset. After all, judicial data is created not by private actors engaged in enterprise in the market. Rather, it is the work of dispersed litigants interacting with, collaborating with publicly funded officials. Judicial data, moreover, is a public asset. The assumption that judicial data is a public asset is baked in to our very conception of a judicial system. There are many, many ways in which, if you have a dispute between two parties, that dispute can be resolved. Arbitration, mediation, et cetera, et cetera. Each comes with its own costs and benefits. By deciding to go to a federal court and in order to resolve a dispute, litigants are opting for the most public and the most public resource intensive path of dispute resolution. They're choosing a public forum which is open to all by default and which is shaped and channeled through the public norms of statutes that determine jurisdiction, rules that the federal courts promulgate. Resolution of disputes through the courts benefits from enormous public subsidies, and it generates binding law assets precipitate. The thoroughly public character of the judicial process, in contrast to alternative ways of resolving disputes, speaks to the fact that what makes courts, and therefore judicial data, distinctive is its public character. Let me sum up. We're at a moment in time at which increasingly it is recognized that data is an important cornerstone of our economy. There are many public and private uses to which data, including judicial data, can be put. My aim in these remarks has been to identify the architecture through which judicial data is presently produced, and to suggest that there is ample room for public action, specifically through Congress, that extracts the public regarding uses of that data in ways that benefit us all. I hope that that project of better husbanding a resource that ought to benefit us all is one that is constant with and advances the spirit of the Sibley lectures. Thank you.
without congressional action. So for example, PACER fees, which they're not that big. I don't have at the tip of my finger the precise fraction of the revenue streams of the federal courts, but they're not as big as they used to be. But PACER fees predominantly come from the last 2 years of litigation, right? So the last 2 years of data produce somewhere well north of 80-85% of the revenue of the federal courts. However, as many of you know, there's lots of interesting questions and lots of interesting information that we can glean by looking at PACER data that is more than 2 years old. And so one of the issues that has come up is, well, maybe we can drop the firewall for PACER for data that's more than 2 years old in order to allow academic research. The other topic that we broached, and I think it's not clear where or how it will go, is the notion of using a large language model to automatically generate notice and suit codes. So I made the point that notice and suit codes are unreliable, but they're probably the best single parameter that tells you what a case is about, and therefore what the distribution and the flow of subject matter in federal court litigation is. One way of making those more reliable is to train a ChatGPT-like instrument to essentially read the entire complaint, right? Not hard for an LLM to do, and then to fine-tune the machine, fine-tune the instrument, so it assigns a nature of suit code that is almost certainly going to be substantially more accurate than individual lawyers doing it. Individual lawyers' decisions are going to be way noisier. That's something that the federal train it on a big sample of complaints, and then you let it loose on the HRC codes, and you actually have a much better sense of how and when people are filing different kinds of cases over time than you do now. And that's got to be valuable for Judge Dow. It's got to be valuable for Chief Justice Roberts when he writes his end-of-year report. This is the pitch that we're making. I don't know whether it will work, but if you don't try, nothing happens.
I mean, along the same lines, do you think we're almost too late for this because we already have Bloomberg and Lexis and Thomson Reuters throwing millions of dollars into this technology? Are they just going to shut anything down that tries to do it with others?
Well, I think that, so the story that comes to mind in thinking about that, which is a really good point, is I take it the general point, let me step back and say what the general point is, and then I'll tell you the story that comes to mind. The general point is that you're making is, look, there's an interest group economy around the issues that this paper addresses. And it would be naive to think that the entities that are currently benefiting from their exclusive access to federal court data are going to sit by idly and allow their revenue stream to be diminished. Absolutely true. The illustration that I would give you of that is, for many years, Joe Bankman at Stanford pressed the California legislature to essentially make its own version of TurboTax, right? And to make tax filing automatic and free. And his point was, look, if you do this, it becomes a lot easier to file taxes, particularly people who are indigent, you remove all these sources of error, you get more tax money, people end up better off, you take out this big source of stress in people's lives, everybody wins except for TurboTax. And TurboTax spent millions lobbying in Sacramento and defeated Bankman's efforts. Right? Absolutely, that is a possibility. The one point that the one thing that I think is different here is that here you have an actor who's actually a better lobbyist, which is the federal courts. Federal courts have enormous sway in Congress, and so maybe there are different patterns of interest group dynamics, but the general point is very well taken.
So I'm curious if you've looked at or thought about how this might affect the type of information that's produced in the future. I mean, once upon a time, discovery was actually exchanged in courthouses,
Yeah.
and so the courthouses themselves were repositories where they got completely overwhelmed by the volume. This was long before you had electronic systems. And so we ended up having an exchange of discovery between parties, which has slowly led to a whole bunch of things being sealed. So I'm curious if you think that if we make information more accessible and more easily available, whether we should also begin to think about having some rules as opposed to standards when it comes to what can be sealed and why.
So I'm completely on board with the point. I take the first part of the point to be, if you change the information on the disclosure regime with respect to litigation, you ought to expect selection effects into litigation. You ought to expect people to alter their behavior with respect to whether they litigate or whether they choose not to litigate. The nature of the selection effect, this is I think your second point, is going to depend upon the rules for non-disclosure. So we spend more time in the paper talking about classes of individual litigants, particularly people who are subject to domestic violence and the like, not so much a federal court problem, but it comes up in certain federal court cases, particularly say immigration cases. How do you ensure access to court for people who want to file suit anonymously? How do you protect those interests? How do you protect pieces of information like social security numbers? Absolutely, any regime of increased collection and increased access at some point has to be accompanied by data security measures that prevent exfiltration or misuse of the data. Obviously, that is a problem for Experian and for all the other credit reporting companies that have all of our financial data, and every once in a while, we're told Experian has a data leak. Right? So it's a general problem for anybody who has a database.
Oh, so I think my point's a little bit different.
Okay, I'm sorry.
So I'm not concerned about, I am concerned about what you're talking about. but my concern is that, in the mass tort context, which obviously Zach writes a lot about as well,
Yeah.
so much information
So I think that I don't want to deny that that's a concern. It sounds from the example that you gave with respect to the opioid context that it's already a concern now, right? That and I made this point about expert reports more generally, that where it is in the interests of both parties to not disclose certain kinds of information, at present that information will not be disclosed as a consequence of agreement or collusion between the parties. So we already are in a world where the kind of problematic non-disclosure that you described is occurring. Would the kinds of reforms that I think the way of rendering the question sharper and more pointed with respect to what we're pushing is to what extent are the reforms that you, Huck and Plotton, are arguing for, are they going to make a bad situation worse? So I think that many of the things that we identify are system-wide or distributional parameters. The notice of C code is one we think is important to reform. Access to PASIN more generally, I think, was important in the way that the other question suggested. I don't think that those kinds of reforms move the needle one way or the other with respect to the problem that you're describing. I can't think of any things that we propose in the paper, reforms that we propose in the paper, that would have much of a material effect on either in terms of mitigating the problem you described or in terms of ameliorating it. So, but I recognize that it's a problem, and I also recognize that once you do something and it has these kind of selection effects that I talked about, it's very hard to know exactly what those selection effects are. You don't quite know how people are going to respond to institutional changes. And I want to concede that it absolutely might be that you do something, you don't intend to make things worse. You've accidentally made things worse by making, say, the record of how many opioid cases were filed in District X as opposed to District Y more available. Absolutely, that's a possibility. I don't think that's a risk that's large enough to not pursue anything, but I think it's also
So your answer to Beth's question gestured at something that I wanted to raise, but I wanted to invite you to say maybe a little bit more, both about free speech and about privacy. So on the speech side, the stories we've told of Congress having relatively unaffected discretion to legislate in this area. I wonder if that at all is complicated by the First Amendment, in that there's a rich doctrinal tradition of thinking that once something is a public record and it's out there, you can't put the genie back in the bottle and hide that information from the public. It's out there. And I wonder if your system here is in any way complicated, or your potential legislative reforms might be complicated by having Congress step in a way to create more sunshine to some of this information, in a way that the First Amendment might thwart some of those efforts. On the privacy front, though, I'm curious not so much about how this could create issues of data security, right, the integrity of the data systems that we set up, but more what it would do to obscurity, right, the privacy issues that people would have in their information. Maybe it's out there, but it's hard to find. Because on the commercial side, one of the tricky things from data rooms, which you write about, is it's public information, a lot of the stuff that's now being sold and put out there. But it was really hard or difficult to find, nobody bothered. And so I wonder if you might say something about that interest in privacy, not just the security.
So I'm not sure I understand, and I'm being signaled, but I should be brief. I'm not sure I understand the First Amendment point, because I take the First Amendment to slice in a different direction with respect under I can't remember the names of the cases, but the press access to court, there was the Richmond case. Right. I take those to be sympathetic to the orientation of increasing access to public records. On the privacy context, so I think that the argument we I think that I think that that is a general problem. It's not clear. I think that in order to address the problem with respect to judicial data, one would need to have a sense of what is it about the world that one can suddenly infer from the existence of the availability of judicial data. My prior about that is that the facts that are open suddenly to inference are not private facts about information. They're facts about the government that the government would reasonably prefer to keep undisclosed. So, for example, imagine that it's possible to study patterns of filings with respect to domestic immigration enforcement or domestic narcotics enforcement, whatever it is, right? And infer from those, or could make predictions about where the government will allocate its enforcement resources in the future, right? And that strikes me as being the more likely scenario. Once one's identified the scenario, I think that the problem of what does one do, how does one manage this kind of uncannonable inference engine, is, I think we're in a world that is a general question that applies to not just state data, but data as you apply that is held by private parties, right? And so I've written another paper which argues that even data that's produced through, for example, location tracking or interaction with social media should be treated as a public asset, and the rules for using that data should be set publicly, constrained by certain constitutional limits. Not a paper that anyone is going to do anything with anytime soon. Nobody's going to act on it. But my own normative preferences would be the kinds of inferential logics that should be available by law ought to be regulated